Now, page 67. So, I was talking about the powers of the Prime Minister, and I was talking that under coalition government, it is very difficult for the Prime Minister also to work and to take decision as he likes. So, he has to accommodate different groups and factions in his party as well as among the alliance partners. He also has to listen to the views and positions of the coalition partners and other parties on who support the the survival of the government depends. So he has to accommodate all other parties which are the part of the coalition, because on their support only the coalition government is working. So that's why it is very difficult for the prime minister to work under a coalition government. So these were the powers of the prime minister we have seen. Now let's see the president of India. While prime minister is the head of the government, the president is the head of the state. So all the real powers is with the prime minister and nominal powers is with the president. In our political system, the head of the state exercise only the nominal power, very less powers. And the president of India is like the queen of Britain, whose functions are to a large extent ceremonial. Okay, only formal functions they have to perform. And the president supervises the overall functioning of the political institutions in the country, so that they should operate in a harmony so as to achieve the objective of the state. And president, he is not directly elected again. He is elected by the electoral college. And who's there in the electoral college? The MPs and MLAs. A candidate standing for president post has to get a majority of votes to win the election, and this ensures that the president can be seen to represent the entire nation. At the same time, the president can never claim the same kind of popular support that the prime minister has. So this ensures that he or she, the president, remains only a nominal executive. And same is true for the powers of the president. If you casually just read the constitution, you would think that there is nothing that the president cannot do. All the governmental activities takes place in the name of the president. All the laws and the major policy decisions of the government are issued in the name of the president. All major appointments are made in the name of the president. So moving to page 68, students, we were talking about powers of the president, that if we see all the major appointments are made in the name of the president, all the governmental policy decisions are issued in the name of the president. Chief Justice of India, judges of the Supreme Court, High Court of the states, governors of the state, election commissioner, ambassadors to other country, all are appointed by the president. All international treaties, agreements are made in the name of the president. And president is the supreme commander of the defense forces of India. But we should remember that president exercise all these powers only on the advice of the prime minister and the council of minister. The president can ask council of minister to reconsider its advice, but if the same advice is given again, then president is bound to act to it. Similarly, if bill is passed by the parliament and becomes a law only after president gives assent to it, if the president wants, he or she can delay this only for some time and send the bill back to the parliament for reconsideration. But if the parliament passes the bill, the president has to sign it. So you may wonder, what does the president really do? Can he or she do anything on her own at all? There is one very important thing he or she should do on her own, that is appoint the prime minister. When a party or the coalition of parties secures a clear majority in the election, the president has to appoint the leader of the majority party or the coalition that enjoys majority support in the Lok Sabha. So whosoever is having majority in the Lok Sabha, that person will be appointed as the prime minister. But when no party or the coalition gets a majority in the Lok Sabha, then the president exercises his or her discretion here. They have a right to decide. They have a freedom of judgment here. And president appoints a leader who in her or his opinion can muster or can collect or can gather the majority support in the Lok Sabha. So here the president has to see which is that leader who can muster the support of the Lok Sabha. And in such a case, president can ask the newly appointed prime minister to prove the majority within a specified time. So these were the powers of our president of India. Moving to page 69, here we have to see the judiciary now. So now let's see one more final time the story of office memorandum that we started with, and this time let us now we should not recall the story, but imagine how different the story could have been. Remember, the story came to the satisfactory end because of the Supreme Court interference, and Supreme Court gave a verdict that was accepted by everyone. Imagine what would have happened in the following situation if there was nothing like a Supreme Court in the country. Then who will interfere? And who will solve all the disputes and the conflicts arising out of the parliament or out of the governmental policy decision? If there was a Supreme Court, if it had no power to judge the actions of the government, then what would happen? Then government will exercise the unlimited power. Nobody can stop the government then. If it had the power, if no one trusted the Supreme Court to give the fair verdict, if this is the condition, then what would happen in the country? So, even if it gave a fair judgment, if those who appealed against the government order did not accept the judgment, then a chaos will be there in the country. These kind of situation will arise. This is why an independent and powerful judiciary is considered essential for the democracy. Independent judiciary should be there. Powerful judiciary. It should not be under the control of the government. All the courts at the different levels in the country put together is called judiciary. An Indian judiciary consists of the Supreme Court for the entire nation. So we have apex court. Only one Supreme Court we have. And we have high courts in the states. District courts and courts we have at the local level. India has an integrated judicial system. It means Supreme Court controls the judicial administration in the country. It is apex court. Then we have high courts. Then we have district and the local courts. And decision of Supreme Court is binding on all other courts of the country, and it can take up any dispute between the citizens of the country. If dispute is between the citizens of the country, between the citizens of the country and the government, between two or more states or state governments, and between government at the union and the state level. So it is the highest court of appeal in the civil cases, in the criminal cases. Civil cases which is related to the dispute like divorce, will, property, and criminal cases of murder, robbery. And independence of judiciary means that it is not under the control of the parliament or the executive, means parliament or government. The judges do not act on the direction of the government or according to the wishes of the party or the ruling party. That is why all the modern democracies have courts that are independent of the parliament and the government. India has achieved this also. The judges of the Supreme Court and High Court are appointed by the president on the advice of the prime minister. So the judges of the Supreme Court and High Court, it is appointed by the president in consultation with uh, the Chief Justice of India and Prime Minister also. So in practice, it means now that the senior judges of the Supreme Court select the new judges of the Supreme Court and the High Court. So there is very little scope of the interference by the political executive here. The senior most judges of the Supreme Court is usually appointed by the Chief Justice. And once the person is appointed as a judge of the Supreme Court or High Court, it is very difficult to remove that person from that position. And it is as difficult as removing the President of India. And judge can be removed only by impeachment process. Say it an impeachment process, it is same for the president and for the judges also. And it has never happened in the history of Indian democracy that impeachment process has been imposed against any of the judges or started or initiated. So judiciary in India is also one of the most powerful in the world. The Supreme Court, High Court, they have power to interpret the constitution of the country. They can declare any law as invalid if it is not according to the provision of the constitution. So, thus, they can determine the constitutional validity of any legislation or action of the executive in the country when it is challenged before them. So, this is known as judicial review. So, it is the power of the courts to decide the validity of the law made by the legislature. If law is not in accordance with the constitutional provision, then judiciary can declare that law as null and void. So, this is judicial review. And Supreme Court in India also have ruled that the core or the basic principles of the constitution cannot be changed by the parliament. The power and the independence of the Indian judiciary allow it to act as the guardian of the fundamental rights. So, in recent year, we have seen courts have given several judgment and directions to protect the public interest and human rights. Anyone can approach the courts if public interest is hurt by the action of the government. This is called public interest litigation, which means litigation filed in the court of law for protection of public interest, such as pollution, terrorism, road safety, environmental issues. So, public interest litigation means it refers to the litigation undertaken to secure public interest and, demonstrates the availability of justice to socially disadvantageous parties. So, public interest litigation is used to raise issues of broad public concern, and courts intervene to prevent the misuse of the government powers to make the decision. They check the malpractices on the part of the public official. That is why judiciary enjoys a high level of confidence among the people. So, for a democracy, it is important that independent and powerful judiciary should be there. We should not be under the control of parliament or the government.